This morning I want to move on to external tribunals and external activities that impact on Australia and our constitutional structure. I have been referring to various organisations which, to my mind, are running off on a tangent from our historic law structures, our historic constitutional structure, and because of their tangents, they are undermining the law in the country just as if they were anarchists. This I believe to be very naughty, but there is a degree of truth in what some of them are saying. You know, if you were in a courtroom and you wanted to mislead the court, how would you give your evidence? There are two things you would do, I should think. One of them is you are asked to detail what you did on the 5th of August 2004 between 4 o'clock and 6 o'clock. Tell me exactly what you did during that time. Now, if you want to mislead, what you will do is to tell me exactly what you did on the 6th of August during those hours. And no matter how a very skillful cross-examiner cross-examines you, you will be able to answer completely as to why you did it and when you did it and so on. It'll be perfectly true, but the date will be wrong. And that is one way of misleading and deflecting even the best cross-examining lawyer that ever existed, by telling the truth but on the wrong occasion. The other one is to mix fact and fiction. And as the judge or the jury hears bits of fact that's obviously fact and bits of something else, they say, oh, well, a bit of it was true, it's probably all true. And that is the other way to do it. Many of the people who are lecturing around Australia at present are presenting part truths. Now, I guess some will say, well, that's exactly what David Mitchell does. Perhaps because they don't agree with me, or perhaps because I oversimplify to the point where an expert in the field would say that's not exactly right. And they say it's only a part truth. So maybe it's the pot calling the kettle black. But I'm saying that there are part truths that have the ring of truth about them because of the true bits in it. Be careful of half-truths. This is an old tactic of religionists. You know, people in cults and indeed sometimes in mainstream type religions specialise in telling half-truths that sound good because it's half there. And unless you are skilled in picking up the deception, it's quite easy to be taken in. There have been very interesting activities, particularly in recent times. It has been said that the question of the validity of the Australian Constitution the validity of the appointment of the Governor-General have been taken to the courts in England. That is perfectly true. They have been. The plaintiff in the case in question, or the applicant, was a New South Wales barrister named David Fitzgibbon. I know David well. I even number him among my friends. I don't know what David was thinking about bringing the cases. They were absolutely doomed to failure. They have hired an expensive London Queen's Counsel, L.L.M to argue the cases in the courts in England. He too is a nice man, and I don't know him well enough to number him among my friends, but he's certainly one of the people I would contact if I were to go to England and seek to make contact with the legal profession. Indeed, on one occasion some years ago, L.L.M was retained for a High Court case in Australia, and I was offered and tentatively accepted a junior brief for the case. I met with Mr. Price, who, as I say, is a lovely man. He really is a fine gentleman. I met with him, and after our meeting I handed in the brief. I said, I'm sorry, I can't work with that Queen's Counsel. The fact was, he just did not understand Australian law. He did not understand that our Constitution is supreme, and he had the idea that Australia was in some way still a colony under British control, and that the Constitution was subject to parliamentary control, if not Parliament in Australia, certainly the Parliament in England. And all this is just wrong. And I said, I'm sorry, we just can't work together. That case didn't get off the ground for the very reasons that I'm mentioning or hinting at. Now, the case in England, Betty Lukes has very kindly made sure that a copy of the judgment is here today. I'm not sure whether this is the one I sent her on the email just before I came, or whether she had it anyway. If anyone wants to read the judgment, it's here for you to see. The English court, in effect, said, go away, play your own Australian games. Look, we're not competent to address Australian law. Australia's an independent country. Maybe you've got a point. I don't know. Maybe you've got a point. If you have, take it to the Australian courts. Now, one of the things that concerns me is the way that these cases have been misrepresented in some of the newspapers, including, I fear, The Strategy, which is, these newspapers are very helpful, but there was a misrepresentation of this case of Fitzgibbon against the Attorney General of the United Kingdom. And it has been proclaimed abroad that they're now appealing to the International Court of Justice. That is not possible. The International Court of Justice is a court that's established in The Hague in Holland for the purpose of adjudicating disputes between nations. And if a case is brought against Australia for something or other by Argentine, the Argentine can bring the case, and the court has jurisdiction if Australia agrees. Australia can say, no, we're not prepared to go before the court, and it's finished. But a person cannot bring a case to the International Court of Justice, not on appeal or anything else. It is only recognised nations that can bring a case to the International Court of Justice. So I'm troubled by the misinformation, the extensive misinformation that runs not just in relation to Fitzgibbon's case, but extensively in these matters. I am puzzled. These cases are enormously expensive. Queen's Counsel do not come cheap. When you lose a case, you have to pay the other side too. And Queen's Counsel for the other side come even more expensive than your own Queen's Counsel. It always happens that way. Where is the money coming from? These organisations that I've been speaking of, Campside and Caledonia and all the rest of them, they're expensive operations to run. Even just maintaining their websites is quite an expensive activity. Have a look at the websites for yourself, and if you've tried to get your own website or been involved in the establishment of a website, you'll know that, while it's not extraordinarily expensive, you got to pay. And all the documentation they produce, and a lot of other things. Who is paying? I don't know. I don't know. I suppose the same thing happens often with religious groups. One wonders where they get all the money for what they do and the buildings they put up and so on. Well, I guess they squeeze their own members. I don't know whether these political groups that I'm speaking of squeeze their own members. I just don't know about that. If they don't squeeze their own members, they must be funded from somewhere. By whom? If anyone can answer those questions, I would be delighted. I've made some inquiries. I've asked one of the Australian security organisations if they will let me have the information in relation to these things, and they say, not interested. They're just, don't worry about them, they'll fade away. Just forget them. Well, it's probably true, but it would be interesting, wouldn't it, to know who funds them? And I certainly don't. Now, there is an organisation called the League of Rights. We know who funds that, and we know that the League of Rights runs on a shoestring, on an absolute shoestring. But these other organisations obviously don't run on a shoestring. Anyway, be that as it may. Then where does the United Nations come into the picture? Yes, it is possible for an individual or a group to make a complaint to the Human Rights Committee of the United Nations. And the Human Rights Committee of the United Nations is quite keen to make decisions that might well affect Australia. One issue that's relatively recent, the homosexual lobby, I suppose I would call it, brought before the Human Rights Committee of the United Nations a complaint about Tasmania's law in which you could be prosecuted for homosexual practices. This actually is public homosexual practices. What happens in the privacy of the bedroom was not prosecutable unless somebody lodged a complaint, unless there was somebody there who was complaining about it. They brought proceedings saying that Australia was in breach of the human rights treaties, often called conventions. Convention is a difficult word because it has so many different meanings. Convention means a historic practice that's sort of become part of the fabric. It also means a meeting, usually a big meeting, often a national meeting of various organisations, and it also means a particular kind of treaty, a human rights treaty. And the complaint was that Australia was in breach of a human rights treaty that Australia had entered into in allowing homosexual practice to be outlawed. The committee said that Australia is in breach, and immediately the Tasmanian government amended the law. But they didn't have to. The decisions of the Human Rights Committee are advisory, not mandatory, so the Tasmanian government didn't have to do that. It was simply a government decision. I imagine there was some pressure from the federal government. I don't necessarily mean the politicians, but federal pressure on Tasmania to do so. So yes, the Human Rights Committee can make decisions that are implemented in Australia. Questions have been raised about Australia signing treaties. The executive can sign international treaties. There's a process, and when I say sign them, there's the question of signing and ratification and so on, but can adopt treaties for Australia. Since the Second World War, a new concept of treaties has come into existence, which are normally referred to as human rights conventions. And the idea is to establish across the world one measure of law, so that a person in China will have exactly the same rights and privileges as a person in Australia. That these rights and privileges will indeed include employment terms, and indeed include remuneration, so that there will be complete equality across the world. Now, it sounds good, and it's not my purpose today, although I would on another occasion address as to whether that's good or bad. But the idea is all mankind should be equal. I know that often some are more equal than others, I have read Animal Farm, and the United Nations system has established a whole series of human rights treaties applying to dealing with all sorts of areas, questions of age, sexuality, political rights, freedom of speech, religious rights, and many of these conflict with one another. When these treaties are established in the United Nations, Australia or any other country can adopt those treaties or need not do so. Once Australia has adopted the treaty, then it becomes part of international law. And as a matter of international law, Australia is obliged to implement the treaty in every part of Australia. Obliged to implement the treaty. What do I mean by obliged? Has it become part of Australian internal law? No, it has not. Not until the Australian government or governments legislate the matter into the law of this land. When they legislate it into the law of this land, it becomes part of the law of this land and is implemented as part of the law of this land. If it is just adopted, if the treaty is just adopted by Australia, you can't go to the court and say, the government or this person is in breach of the treaty. They're not enforceable in the courts. Although there has been a decision of the High Court which says that while they're not enforceable, they should be taken into account, and Australian law should be administered having regard to the treaties, whatever exactly that means. I think I know what it means, but it's far too complicated to try to go into today. The government enters into treaties without the approval of Parliament. It just decides to enter into them. And if we don't observe them, we're in breach of international law. If we're going to be a law-abiding nation, we must observe and abide by the treaties and their specific terms. There is no way of enforcing them. There isn't an international armed force to come into Australia and take us over because we haven't observed a treaty. You're driving from here to Melbourne. You know that the speed limit is 110 all the way from here to Melbourne, but there's no police car behind, so you slip up to 150, 180. Are you breaking the law? The answer is yes. It's not a question as to whether it can be enforced or not, is it? You abide by the law because it is the law. Not because of the penalty or sanction that will attach to breaking it. This is an issue that we had when we started fostering our young girl. She was of the view that anything was all right so long as you didn't get caught. And she had developed that view as a result of the simple thing of her father exceeding the speed limit. And she would say to him, "You're breaking the speed limit, Dad." "No, it doesn't matter, we won't get caught." And she said, "Surely that same thing applies even to shoplifting. That's all right, so long as you don't get caught." Now, how do we relate to that? Do we say we want to be law-abiding citizens because it is the law? Or do we say we want to be law-abiding citizens so that we don't get caught? It's pretty important for all of us. Equally, it is important for the nation of Australia in the international law field. Do we abide by the treaties so that we won't get caught? But we won't get caught. There's no policeman. Nothing's going to happen. It's just a question as to whether we observe the law. The answer to that is, or ought to be, I believe, yes. And I personally believe that the country, that the government, should not be hasty to enter into treaties. One interesting treaty that's in dispute at the moment is the Global Warming Treaty. What's it called? The Kyoto Protocol. Thank you. That's exactly what I wanted. The Kyoto Protocol. Australia has not signed the Kyoto Protocol. Why should Australia sign the Kyoto Protocol? Well, I mean, we ought to observe those things. We ought to keep down our emissions, shouldn't we? Do we have to sign the protocol to keep down the emissions? No, of course we don't. To give protection to homosexuals, if we were to want to do that, do we have to sign an international treaty to do that? No, of course we don't. This was the big argument I had in relation to the Convention on the Rights of the Child. Some of you might remember the big dispute that went on, and I became very involved in that campaign. I kept saying, children do need protection. Children do need to have laws to ensure that they are not maltreated. There must be some means of protecting defenceless children. But we don't need to sign a treaty to do it. If we believe that the things in the treaty ought to happen in Australia, just legislate them. Don't bind the country, don't bind the nation so that we can't change our law. You see, once we enter into the treaty, we're not in control of our own law. And this to me is so clear. I'm perfectly happy for the treaties to be drawn up in the United Nations, for the document to be drawn up as a standard, but I'm not happy for the United Nations or the world community to control our country in the way that these are implemented. I hope I'm making myself quite clear to everyone. It's often said that we should withdraw from all treaties. I don't really want to do that. International agreements, for example, provide that aircraft flying east to west will fly at even 1,000 feet, and from west to east will fly at odd 1,000 feet, so that there won't be a collision in the air. It's just like having rules as to which side of the road you will drive on. And I'm personally perfectly happy for Australia to enter into a treaty of that nature, because it is a truly genuine international matter. I'm very happy for Australia to enter into a treaty either through the United Nations or individually to recognise the postage stamps of other countries, for example. And there is such a treaty, and a very important one, so that you can go overseas, you can post a letter with their local stamps on, and they're not thrown in the waste paper basket when they arrive in Sydney because they haven't got Australian postage on them. I'm very happy to recognise the stamps of other countries, and I'm happy for a treaty because I want them to undertake to recognise ours also. I'm ambivalent about extradition treaties. I find problems sometimes with extradition treaties. I was working in a country that did not have extradition treaties or extradition arrangement with its surrounding countries, and I had the privilege to have some responsibility for the law and its administration, and I persuaded the government to introduce a law that has since been repealed because everybody protests that it's absolutely ridiculous. The law that we introduced was that it is an offence to cross the border inwards or outwards with any money or negotiable securities, and it is an offence to cross the border without any money or negotiable securities. That sounds ridiculous. You're gone either way. Yes, that is perfectly true, and that was the whole idea, that there were no extradition arrangements with the neighbouring countries. There was somebody crossing the border who was under suspicion, nothing that could actually be pinned on them at the moment. The police investigation was proceeding. They get across the border and they're as free as a breeze because one of the neighbouring countries in particular would never extradite to the country I was in. And I said, look, you just got to be able to hold him. And you've got to have something that you're going to be able to hold him on, whatever he does. And either you have a completely totalitarian law saying you can hold anyone, or you have something specific. And we introduced the specific. Now, I guess that the law that I promoted and provoked was totalitarian, anti-human rights, restrictive, and so on. But of course it depended how it was administered. It would have been possible to administer it in an unreasonable and cruel and harsh way. As far as I'm aware, that never happened, but perhaps it did. I never had a complaint about it. There is a new court called the International Criminal Court. I have got a lot of worries about the International Criminal Court. Australia has adopted the International Criminal Court Treaty. The United States has not done so. It will be possible for any Australian individual to be charged on the complaint, I think, of any person with an offence against international criminal law, whatever that is exactly. Certainly, one of the international offences would be unjustly waging war. It's surprising to me that no one has charged Prime Minister Howard in the International Criminal Court. Whether he is unjustly waging war or not, I'm not prepared exactly to say, although I would not have supported the move on Iraq, and lots of reasons why I wouldn't have, but they don't fall into my brief for today either. But the International Criminal Court is a bit of a worry. You know, have I made some comments, or has our friend Dr. Tobin made some comments that might fall within the ambit of international criminal law? Could he or I be brought before the International Criminal Court as an international criminal? It really worries me, because the authority for the law is moving outside Australia. I'm not suggesting at this time, I'm not suggesting that the Australian government could not introduce similar laws. But why don't we deal with them in Australia? Why do we let it slip outside Australia? This is a real worry. The courts in England know this so well, and this case of Fitzgibbon and the Attorney General is a marvellous precedent and example where they say, "Oh, go back, do it in your own country. If there's something wrong, do it there. Do it there. And nothing to do with us. We're a foreign country." And that, to my mind, is exactly right. The judge didn't say, well, you're totally wrong. The judge inferred, I'm sure you're totally wrong, but he didn't say that. He said, if you're right, go and do it where you ought to be doing it. And that is being used to say that the judge indicated that they were right. So next we need to move to we need to move to some other groups that are destabilizing groups at the moment. Frankly, one of the destabilizing groups is the political party known as the Greens, as the Australian Greens. They have grabbed onto the issue of protection of the environment, but as one looks at their policies, and very few did at the last election, I believe, we see that they would propose to legalise nearly all psychotropic drugs, like heroin and marijuana. They are to be legalised as a matter of human rights. You should not be restricted in these areas. they would open the borders of Australia to migration by anyone who chose to migrate here. Well, I can understand that if we were to sing what they now call the national anthem, for those who come from all the seas, we've boundless plains to share. We don't often sing that verse, but I think some would be a little concerned if we did. So while the Greens have probably much to commend them, they also have much that I criticise them for. And I see them as a completely destabilising activity in the country. I say that as far as the protection of the environment is concerned, that one of the things the church has done, or rather hasn't done, the church has forgotten its general responsibility for guarding God's creation. If the church had been taking proper activity over the years, the Greens just would not exist, and the very dangerous green policies would not exist either. I do commend to you that you do look carefully at the detailed policies of the parliamentarians that you might be voting for or campaigning about. Now, policies, of course, are one thing, and the way they implement them is another. We were talking previously about whether this country is a democracy, a totalitarian nation, or an anarchy, or whether we are following the historic idea that the law exists. The historic idea is the law exists from God through the scriptures. I've been told this morning that the Treasurer, Mr. Peter Costello, declared on the radio that the Ten Commandments is the basis of the Australian law, and that the Ten Commandments are entrenched in the law. He's absolutely right. If that's what he said and what he meant, he's as right as can be. Why would he be saying it? Well, I will be coming to that this afternoon as to why he might be saying that sort of thing. But of course he's right, and I hope that he's being genuine in that regard. Another divisive issue is the question of the Aborigines. Do we need to take particular care of the Aborigines, to have special laws for them? Possibly so, but the aim is obviously to establish a separate Aboriginal nation within Australia. Aboriginal passports are already being issued. Aboriginal flag is already being flown. Aboriginal land rights claims are being granted, and land use claims are being granted, and reconciliation agreements are being established. Reconciliation agreements, of course, the Gurna Tapa era agreement was signed yesterday. What's the Gurna Tapa era agreement all about? It's allowing the Aborigines particular rights over Crown land in 4 council areas in the Adelaide area. The thing that I suppose interested me most is the term Tapa era, the road home. In other words, the Aborigines are just on the road to where they want to be. Do they wish to take over the whole country? I don't know. Is there an agenda behind it? I don't know. But I do know that the issues are divisive. I do know that they are undermining the legal structure of the country. I believe they could be dealt with satisfactorily in another way. Another group that is currently destabilising is the thrust of Islam into Australia. This is demonstrated in recent court cases in Queensland and Victoria, where in Victoria two Pentecostal pastors have been found guilty of human rights breaches in making public exactly what the Quran says. The reply of the Islamists was, well, that's not really what it means. Now, I can understand them saying that, because even as we look at the scriptures, there are some things that if you just pull a text at random out of the scripture, for example, unless you hate your mother and your father and your brother and your sister, you cannot follow me. If you pulled that out of the scripture, said, look, Christianity teaches hate for families. I would be saying, no, that's not exactly what it means. You need to look at the context. You need to look at the other parts. You need to compare scripture with scripture, and so on. So I understand a little bit of what they're saying, but the Pentecostal pastors in question were not pulling out of context, and they were just presenting what the Quran says. And in the courtroom, the Islamists said, yes, well, there are some people in some countries that believe that, and we don't, and we're being denigrated by having this presented as something that we believe. It's not something I believe, said the witness. Therefore, I am being denigrated because I'm Mohammedan, and that offends them, by the way, to call them Mohammedans. Anyway, they were found guilty, and they were ordered to do a number of things, including putting a half-page apology in the leading newspapers in Australia on several days, including putting a link to the Council of Islam website on their own website, including removing offensive comments, including undertaking never to say any such things again, and the two Pentecostal pastors have declined to do those things. They've now lodged an appeal in the Supreme Court of Victoria, so we shall see what happens. I understand that we need to finish at 12 o'clock and that there should be a quarter of an hour for questions.
Doctor, I'd just like to get a further explanation for what you said about the question of yourself and Dr. could be in the dock over your attitudes towards the Iraq War. Now, would that be similar to the imprisonment of certain English people at the time of World War II, Section 18B, I think it was, because they opposed Churchill's declaration of war on Germany, and therefore they were regarded as seditious?
If I said that my friend Dr. Tobin and I could be charged in the International Criminal Court in relation to our attitudes to the Iraq War, if I said that, I would want to withdraw it at once. I do not recall putting any reference to the Iraq War in that comment. If either he or I or any of you were to offend against a principle of international law, we could be brought before the International Criminal Court and judged. You know, we do it in Australia, and the judgment could be in a court that is not an Australian court, that there is no Australian jurisdiction. No, I'm not making any such suggestion with regard to the internment of people in Britain, or indeed the internment of people in Adelaide. You might be aware that at the outbreak of the Second World War, the Adelaide Company of Jehovah's Witnesses was interned because of their opposition to the war, and their not just their opposition to the war, but the way they were actually opposing Australia's war effort. But that's not what I was talking about at all. That happened within the Australian legal system. What I'm talking about is matters happening in Australia, and I was thinking particularly of Mr. Howard, but I wanted to bring it down personally to you and me. I was thinking of Mr. Howard. Could he be prosecuted in the International Criminal Court for instituting a war against Iraq?
Thank you. The next question is over here. Yes, sir?
Dr. Mitchell, I've had it said to me recently several times that our constitution is illegal because it's a British constitution or an English constitution. Can I have your comments on that, please?
Yes, we did look at that yesterday. Covering some of the ground we covered yesterday, it was a constitution, it was a document drawn up in Australia and voted on by the Australian people, and it is not a constitution as such, but an agreement among the states as to how they would operate together. How was that to come into effect? I suppose every state could have passed identical complementary legislation so that it all came together, but they decided that they would ask Britain, who was the ruling power over the state colonies, to legislate for Australia. They could have had a unilateral declaration of independence. They could have shot the British representatives. There are many things they could have done. But the Australians decided to do it this way. And certainly it was legislated in the Parliament of the United Kingdom, but at the request of the Australian people. The British government recognised then, and always has recognised, that they have no power or control over the Constitution itself. It has devolved to Australia, so that it is the fundamental Australian law. Indeed, it is the founding document. If you like, if you care to look at Britain as the colonial power, you can say, how did Britain give Australia independence? And I say, and the late Lionel Murphy says, that Britain gave Australia independence by virtue of this document. And this is the document by which we got the independence, and it has become our own document.
Yes, sir.
Dr. Mitchell, it's a more than passing concern to me that people are going off overseas, and perhaps not even going overseas, to challenge things like our constitution and appointment of our officials, and the reporting of them, which is in itself seems to be misleading. Are there any restrictions on sort of the maintenance of action against these cases, that if the money comes from somewhere or other, that they can mount such a case? It's, I gather that ordinarily in criminal law a person can't bring a case if it's funded by somebody else. It's
Champity.
yes.
One of the great privileges we have in Australia, we are complaining that we are under a totalitarian government, at least I am. I'm complaining about the sort of thing, Chris, that you're raising. I'm complaining about all these things. But despite all these things, we're one of, if not the, freest country in the world. And you do and get away with all sorts of things, like the issues that you raise. And in one sense, it's wonderful that we have the freedom to do that. But yes, it is worrying, for it is attacking the basis of our law. And there are provisions in the laws of the various states, and indeed the Commonwealth law, that appear to be being breached. The authorities choose to take no action. It would be possible for an individual to take action. How far you would get would depend on what exactly you were complaining about and how you could evidence your complaint.
Yes, sir.
Dr. Mitchell, do we know how many treaties have been signed without the approval of Parliament, just by the executive?
Yes, we do, but I'm not able to tell you at the moment. If I had my files readily available, I could probably tell you, but it's in the hundreds.
Thank you.
It's probably all of them. Any more questions?
Well,
Yes,
got a moment.
yes, sir.
Dr. Mitchell said probably yesterday that the Constitution gave the powers to the Governor-General to act instead of the Queen.
Yes.
Now this puts us in a position where many people say, well, therefore, what is the relevance of the Queen today? Could you cover that for me, please?
Yes. Again, covering it for the second time, the relevance of the Queen is simply the responsibilities of the monarch to maintain the law of God, to maintain the laws of the respective peoples, to maintain the historic Australian laws. That the Governor-General does not take these oaths, but is the representative of the Queen for implementing the oaths that the Queen has taken. The executive power is in the Governor-General, not in the Queen. Section 61.
Mr. Chairman, I'd like to ask Dr. Mitchell, would he like to comment on the extent of the land mass that comes under the Aboriginal, either successful claims, pending claims, or claims now in the court? Just the extent of the land mass of Australia that we're looking at.
I would love to comment on it, but I don't know. It might be that somebody present does know.
Well, it's a long time since I've seen the map, but it's very large.
It is very large, and it is growing. Now, the Rose Hill claim is quite a big one, which has just been decided in favour of the Aborigines. An appeal has been lodged. And the lawyers, the Rose Hill lawyers, are anticipating that it's likely to be a successful appeal.
Yes, sir.
Can you tell us which model would probably be the best model compared to Canada, New Zealand, or the one that we seem to be adapting here in dealing with the Indigenous people?
I can't tell you the best model. I would suggest that as far as the Aboriginal people are concerned, and I'm using the term Aboriginal advisedly, although I'm not quite sure that I'm right in that. You see, I've been to my dictionary, and I went again to my dictionary, or to rather to Doug Giddings's dictionary yesterday, to find out what indigenous and what native means. I found that indigenous means native, and that native means born in a place. That a native of Glasgow is somebody born in Glasgow. Therefore, I'm a native Australian, therefore I'm an indigenous Australian. And as far as the dictionary goes, there can be no doubt about that.
I rephrase my question?
I don't think you need to rephrase your question. I understand and know your question very well. It seems to me that the question is answered by reference to Acts chapter Acts chapter 17, 19, Acts chapter 17, verse 26. From one man God made every nation of men that they should inhabit the whole earth, and God determined the time set for them and the exact places where they should live. God did this so that men would seek him and perhaps reach out for him and find him, though he is not far from each one of us. That the whole idea is that there should be a one nation, a brotherhood, a full integration, that we should not be establishing separate rules within the one country for different groupings. The fact that we are, ladies and gentlemen, is partly my fault, and you older people, partly yours too. For in 1977, we had a referendum in Australia, and for the only time in my life, I voted yes in the referendum, and I regret that. I repent of doing that. Section 51, placitum, or placitum if you really are a Latin scholar, placitum 26. Some people say subsection 26, but it is not. It's it's one of the placita. The people of any race, other than the Aboriginal race in any state, for whom it's necessary to make special laws, may be legislated for by the Commonwealth of Australia. Any race other than the Aboriginal race, the Commonwealth could make laws for. In 1967, the people of Australia were asked whether they would allow the Commonwealth government to make laws for Aborigines. I said yes. It seemed at that time to me to be discriminatory. Discriminatory, my fat foot. If we're going to be one nation together, you don't want special laws for the Aborigines. You want the law. You don't want the Commonwealth making special laws for the Aborigines. There might be particular reasons in a particular place in a state, such as some of the areas in South Australia, where the South Australian government might need to make some special laws relating to them, but a national law on a race basis should be quite unnecessary. And it is because the Commonwealth can make laws for the Aborigines that half our problem has arisen. And I was the person who voted in favour of it. Sorry.
Chairman, I just wanted to make comment that we in our sloppy thinking, and I include myself in that, what we haven't grasped, as Canon Arthur Fellow says in his Foundations of Liberty, and similar material, that the concept of a nation only came through Christianity, that it is a very modern idea. And, you know, we don't understand that. Would Dr. Mitchell like to comment on it, please?
We find nation referred to in the earlier part, historically, the earlier part of the Old Testament. We find nation referred to as Abraham being the founder of a great nation. We find reference to the nations round about, and what in general terms it was meaning was a people grouping rather than a geographical area. The idea of a geographical area being a nation is a relatively modern term, and it's been established for reasons of government, and it makes life easier in the modern world if you can have your geographical areas. Should we have national borders, or should we have racial borders? That, I think, is the question. I would say that it's much easier to have national borders than racial borders. If we're going to have racial borders, it seems to me that there is enormous difficulty in modern political structures. But maybe we ought to look to racial borders, and maybe we should have really put some effort into establishing a multicultural Australia, so that there are different laws relating to every racial grouping that comes here. I don't think so myself, but maybe it's something we ought to look at.